The third segment will be the questions from the judges. Each team will have a total of 12 minutes each to interact with the judges. The 12 minutes will include the time taken for the judges to ask their questions and for the teams to answer them. There will be no time limit on each response. Judges may direct their questions specifically to a speaker or to a team in general at the judge's complete discretion. When a team has 1 minute remaining on its clock, the bell will be rung once, and the timekeeper will point to the team being so notified. When a team has utilized its full 12 minutes, the bell will be rung twice, and if the speakers are still speaking 15 seconds after the end of the allotted time, the bell will be rung continuously. I'd like to remind the judges to kindly preface their questions with which team or speaker they are addressing for the purposes of timekeeping. I would now like to invite the judges to engage with the teams at their discretion.
I do have a suggestion before I begin, that the time that the judges take to ask the question not be included in the time, because we can be quite long. But anyway, I leave that to you. I have a question for the opposition first. For the proposition first. You talk about the checks and balances, and I didn't really hear a full answer on whether you thought that the checks and balances were sufficient. Essentially, you've got the police or the investigative authority who come up with the report, the Minister of Home Affairs who then decides whether to detain or not, and then the President. Then you've got a panel of advisors that decide whether the detention should continue, etc. Essentially, everything emanates from the report or the investigation that the police carry out. The President's decision, the Minister of Home Affairs' decision, the panel's decision, everything emanates from the investigation that's carried out. Nothing is independent, nothing comes in from a third party. Is that sufficient check and balance?
Thank you for your question. Yes, first we believe there is sufficient check and balance because each of these individuals or levels of checks and balances all have an incentive to make sure that they don't abuse someone because they're most of the time democratically accountable to the people. In the case of the President, in the case of the Minister of Home Affairs. But just in case you think these checks and balances aren't enough, we're going to paint you a broader picture of checks and balances because in today's Singapore's day and age, you now have a parliament that's increasingly more diverse. You now have an international media which focuses a lot of scrutiny on the Singaporean government. So what does this mean? It means that you see instances like recently elected Minister of Parliament Janil Puthucheary asking for checks and balances in the ISA, for ex-NMPs calling for information in Parliament from the Minister of Home Affairs in order that civil society can start asking some very good questions if there are suspicions of abuse. In fact, in 2002, the ISD released detailed reports on their website about who they had recently arrested, their educational and religious backgrounds, and why they were a threat to Singapore under the pressure of media questioning. So not only do you have a series of internal checks and balances at multiple levels, you also have a wider set of external checks and balances in society. And that's why this system works. I hope that answers your question.
Following on with this question of checks and balances, this is directed at the proposition. It's a central tenet of your case that the judicial system and judges are not the appropriate institutions for review of security matters. I'm correct in that? Yes. Looking at the ISA, one of the checks and balances that we do have is the review board? Yeah, the advisory board, which is led by a Supreme Court judge. This is the same Supreme Court judge that you also told us is not qualified to make an assessment of the nature of the case. Is there inconsistency in what you're saying, or is there a way of reconciling these two? In which event I would be interested to hear how you reconcile it.
There is a way of reconciling the two, because I would never dare come into a place like this with the intention of insulting so many lawyers around me and potentially judges to be. The judge in a courtroom is very different from the judge in his capacity as a legal advisor on the advisory board. And that's why we want the judge to bring his expertise in, but not ultimately be bound to take action by the strict criminal codes, because as we've argued to you today, that is inappropriate. But I think the second difference which allows us to reconcile this seeming tension is that the advisory board, unlike in the courtroom, is not compelled to reveal all information to the defendant, neither is it compelled to ask for all witnesses that are relevant to the case, which means that the judge can, as team opposition has conceded, consider some evidence without compromising on the validity, integrity, or the communication systems and the networks of intelligence that we have. So this is why we strike a better balance between including some elements of justice and the legal process and legal knowledge, while at the same time buffering ourselves and protecting society against future threats. And that's why this is not a tension.
Following from that, the judicial power is part of the basic structure of the Constitution, and its exercise through judicial review is the cornerstone of the rule of law. So it is the means by which the courts check illegality, whether of the legislative or executive acts. So for the proposition, this question is for you, I think it's twofold. Firstly, do you agree with that statement? Just to help you, these are not my words, happens to be the words of the Chief Justice, our Chief Justice, not Lord Diblock. And this is an excerpt from his lecture, The Courts and the Rule of Law in Singapore, at the Rule of Law Symposium given in February this year. So would you agree with that statement?
Sorry, could you ask you to repeat the statement again?
Yeah, sure. The judicial power is part of the basic structure of the Constitution, and its exercise through judicial review is the cornerstone of the rule of law. It is the means by which the courts check illegality, whether of legislative or executive acts.
Yes, we agree with that statement.
So if you agree with that statement, given that the ISA is not subject to judicial review, how does that gel with your proposition that detention without trial is justifiable in Singapore?
Okay, there are two levels of things we want to say to this. And the first thing we want to say is that, three things, I'm sorry. The first thing is that there is a certain degree of judicial review, which is to ensure subjectively, a subjective test to ensure that the procedures of the ISA are being carried out. The second level of response is the CLTPA and the MDA are still subject to objective judicial review, in which case I think that your point is primarily referring to the ISA. So we just want to point out that in a significant majority of cases where detention without trial is used, this point still stands. So this suggests to us that even though the statement you gave us was definitely true, and we agree with this, there is always room for some degree of qualification, and in this case we have justified this qualification on the grounds that if you do use a court system in this unique situation of national security, you end up compromising on arguably the most important aim of justice in the first place, which is to protect innocent lives both now and in the future. And this is why, even though we agree with your principle, we still stand by our stance, which is that there is a unique situation, or there are unique situations under which the ISA and detention without trial is justified.
Okay, switching across the floor to the opposition. Joshua, in your closing, during the interrogatories, your closing statement, you mentioned that the arbitrary determination by the President for whether to allow or to veto the detention of an individual. I presume we are talking about detention under the ISA in this scenario. Why do you say it's an arbitrary decision? Can you expand on that, please?
I think our reasoning behind this was that the institution of the President under the ISA has the ability to make a decision without any kind of independent review of the rationale for that decision-making process. So the problem is not, we don't have a problem with the individual or with any individuals who are within that institution. What we have a problem with is the mechanism and the design of the way that the ISA is being used, and is being used to justify detention without trial, and the kind of checks and balances that they're using to justify it. because we think that those fundamentally do not allow for the independent review and objective review of a third party within this process, which we think under state construction and under the Constitution of Singapore, the judiciary was always meant to preserve and to stand for. And so we think that because of that, it is kind of arbitrary in the way that the president can veto or not veto detention without trial. And we think that fundamentally, courts should have the ability to come in and to examine that process and to examine the guilt of individuals who are accused.
But why is the review by the court not arbitrary and a review by an advisory board, which consists of at least one Supreme Court judge, and the review by the president arbitrary? Why this distinction?
I think this comes down again to the procedures that actually occur within a court. And up to this point, I think that as well, proposition hasn't been able to deal with the fact that the Minister of Home Affairs and the advisory boards don't need to actually call all the witnesses who are germane to the particular accusation or crime which is being accused of individuals who are being detained without trial. We think that because of that, that fundamentally prejudices the entire process, because there isn't an objective two-sided view of what's going on as well. And we think that also the fact that the minister and the advisory board can consider evidence within the inquisitorial process, which is not admissible within court, is also another problematic clause or problematic procedure which occurs within the advisory board, which doesn't really allow for the full kind of check and balances that a trial system has. So because of those things, we think that the advice that the advisory board gives to the president is also fundamentally unsound, and we don't stand for that kind of advice or the process by which it was derived either.
What I gather from your answer is that you consider the ISA procedure arbitrary because it's inquisitorial in nature, and arbitrary because it allows admissibility of evidence which would not be admissible in a court of law. But these are not indicia of arbitrariness. They're just different criteria. Many judicial systems in the world have an inquisitorial nature rather than an adversarial nature. There's no special magic in an adversarial court system over an inquisitorial court system. It's an accident of history more than anything else. So if you come to me and you say any system that's not adversarial, any fact determination system which is not adversarial is by its very nature arbitrary, that is not an argument that I can accept. Would you like to respond?
Thank you for the question. Now, the reason we believe in the adversarial system is the reason that lawyers and judges across Singapore and across the Commonwealth believe in the soundness of common law and the systems common law has established. What we think is that the adversarial system isn't just an accident of history. It's an advantage which common law affords over inquisitorial systems which are used in some civil law jurisdictions.
Okay, let me stop you there. So, what are you going to go and tell the French?
I think we have...
Are you going to tell them that, sorry, your 300 years of constitutional and legislative history should be put in the dustbin?
We don't think that an inquisitorial system is entirely unsound, but what we do say is that an adversarial system is more sound than an inquisitorial system. And let me explain why. The reason for this is that in an adversarial system, the judge can consider both sides of the argument and see how the arguments play out, which one is more sound. In an inquisitorial system, on the other hand, the judge is actively arguing against one side of the evidence. And because the judge or the magistrate has a responsibility for finding out the details of the crime and for judging whether these details are true or not, he can possibly ask leading questions, only finding out one side of the case and therefore judging a case based on one-sided evidence. And we think that because of the inquisitorial nature of the advisory board, where there is no adversarial process, the judge can do this, and therefore the guilt or the case for detention against the accused isn't as sound as one which would occur in a court.
I think we've heard a lot from the opposition on the legality, or rather the illegality of detention without trial. Does opposition agree that the Constitution is the supreme law of the land, Singapore? Maybe we can answer that first.
Yes, we agree with that.
So under the Constitution, if it's permissible, if detention without trial is permissible, so the question is, what's the beef?
We agree that the Constitution is the supreme law of the land. And we agree, the Constitution does say that detention without trial is permissible. But the question here is, should this Constitution, as it currently stands, be the supreme law of the land? And we don't think so. We think that detention without trial, as legitimized by the Constitution, isn't something which is ethically right. And so we stand for changing the Constitution. When we change it, because it's going to be changed by the vote of Parliament within a democratic process, then that Constitution will be the supreme law of the land, and we think that that's a more just law.
I'm going to push you a bit on the adversarial and inquisitorial system. First of all, I hope nobody in here is French or European, because actually you'll probably find that the inquisitorial system and the civil law system is more predominant than the adversarial system in the world. Secondly, if you've ever been to a court of law in Singapore, it sort of teeters between adversarial and inquisitorial because the judges do play a very, very active part in inquisitorial. Thirdly, your argument presumes that the defense advocate on one side is competent enough to present the case and superior enough to raise the evidence. If he is not, then the system fails. I think you will agree with that too. So it is then down to the judge again to make up for the lost ground that the defense advocate fails in. So these are all the failings of the adversarial system. Where do you stand? And therefore it cannot be that the inquisitorial system in itself fails. The second thing I'd like to ask is, since we're on the judicial process, I'm going to ask you again, one of the points that is raised by the proposition is that the judicial process is not nimble enough to preempt a terrorist attack, for instance. How do you address this?
Thank you very much for that question. I'm going to start off with the question on the mechanism of the adversarial process. I think that what fundamentally makes Singapore's adversarial process clearly an adversarial one is the burden of proof that we place on the prosecutor and how we refuse to presume guilt of an individual, but instead presume innocent in the majority of cases. I think this protects Singapore's adversarial process. But more than this...
Let me stop you there. They have the same burden in an inquisitorial system in France and in most of Europe.
Okay. And on the issue of France and Europe, we think that while we think the adversarial process is the best, firmly we believe that it's the most moral and legally justified. But at the same time, we think we are not in a position to condemn that of other countries. However, we think that this debate takes place in Singapore and the Constitution of Singapore capturing Singaporeans.
Okay, let me ask you this. I'm going to stop you on this. Sure. Simply put, detention without trial would be justified if the check and balance was an adversarial system.
We think...
Yes or no?
We think that detention without trial can... No. The reason for this is that we think that there is an inherent difference between a trial system and that of any form of detention without trial, be it in the status quo or any form of future process. Here's the reason why. We think that in the status quo, the current process can never work because of the people who work in it. We've already proven to you how the different checks don't work. We've further proven to you how the people involved in it are not trained legal experts, or at least don't act in their capacity as trained legal experts. And
the Supreme Court judge sitting on the advisory panel is not a trained legal expert.
We think that the Supreme Court judge sitting on the panel acts in his capacity as the layperson. He is not expected to prove guilt beyond all reasonable doubt.
He does not change his brain when he comes in. He's still a trained legal expert, just as I'm sitting here cross-examining you.
We definitely agree with that, but I think both proposition and opposition have agreed to this, that the Supreme Court and the judge who sits on a panel does not sit in his capacity as the Supreme Court judge, and we think that that is the fundamental difference. We think that an individual with the knowledge and the field of experience is not the same as an individual who sits in his capacity as the Supreme Court judge with the same checks. We think that even if he sits on a panel with his knowledge, we think that this doesn't constitute the same kind of check as a conventional trial system.